we are in court because the petitioner filed a petition against the first and second respondents. And the basis of coming to court is that he's seeking legal redress, not redress from public opinion, not redress from the streets. And anytime you proceed to court, there is a basic principle that you proceed on the strength of your case and not the weakness of your opponent's case. So when you come to court, you must be rest assured that the pleadings contained in your petition, your applications, your witness statements are enough to substantiate your case, so that you reach the kind of threshold that the court will allow for the release you are seeking to be granted. So you can bring me to court, and I can choose to say I won't say anything, and that will not be in breach of law. As my sister Nanajwa mentioned, we have freedom of expression, but we have rights not to speak. So it is a fundamental law that you cannot compel any witness to go and stand in the witness box to testify. So on the basis of that, you would expect that the petitioner, former President John Dramani Mahama, came to court because he was convinced that he had a very good case and he had the evidence to prove that case. Now he has called 3 witnesses, although he had hinted the court through the petition that he was going to call 5 witnesses. Nobody has compelled the petitioner to call the additional 2 witnesses. In fact, the petitioner himself is not a witness in the box. But yesterday, the petitioner's lawyers mentioned that they've closed their case, meaning it is now up to the respondents to decide what they want to do with their case. And they also hinted the court that we have closed our case because so far, from the 3 witnesses that the petitioner has called in court, we've realized that they have not been able to adduce enough evidence to establish that nobody won the election, that the declaration was in breach of Article 63, Clause 3, that there were vote pardon which were enough to overturn the outcome of the election, or any of the other reliefs that they sought through the petition. And if that is the case, if your case is weak on its own, I need not waste my breath to even go and stand in the witness box to punch additional holes in your case. So it is for the petitioner to be excited that the respondents are not even willing to even get in the box.
Why should they be excited?
Because they should have confidence in their own case and believe that they've made a strong case for the court to grant them the release. But as it appears, they know that their case is weak.